When state public utility commissions throughout the nation approve new rates, they do so following cases that really resemble civil court cases. Indiana's process is no exception. In this video, we will walk through the steps of a typical rate case. First, an overview of the parties. The Indiana Utility Regulatory Commission is the body that considers evidence and makes the final decision. It's essentially the judge and jury, and state law requires the commission to balance utility interests with ratepayer interests. The party with the burden of proof is the utility itself. The Indiana Office of Utility Consumer Counselor, or OUCC, is the party representing the interests of all consumers in commission cases. The Consumer Counselor's Office has attorneys, accountants, economists, and engineers who review the utility's request and submit testimony and recommendations on behalf of the public. Under state law, the Consumer Counselor's Office is a party to all cases before the Commission. Finally, state law allows additional parties to intervene through attorneys if they wish, and this usually happens in large cases with major utilities. A typical rate case starts when the utility files its case in chief. This includes testimony written by expert witnesses along with accounting and engineering exhibits and work papers. The full package can be dozens, hundreds, or even thousands of pages in length. If the package of testimony and evidence is complete, then state law sets a 300-day time limit for a final order from the Commission. Each IURC case is given a 5-digit cause number. In the case's first few weeks, the Commission will approve a schedule of filing and hearing dates. The Consumer Counselor's Office and the utility usually negotiate a schedule for the Commission's approval. As we go along, the numbers on the left side of your screen will show the general guidance the Commission has given for a rate case's timeline. As the Consumer Counselor's Office starts using its legal and technical resources to analyze the utility's request and develop testimony, it also invites public comment. Any customer of the utility, whether a residential, commercial, or industrial customer, is welcome to send written comments to the OUCC by mail or email, or through the electronic form on the agency's website. Any comments the Consumer Counselor's Office receives at least a week before its testimony is due is included with the agency's filing to the Commission. That way, the written public comments become evidence in the case's record. In certain cases, the Commission will hold a public field hearing to receive oral consumer testimony under oath. Oral testimony at field hearings and written consumer comments filed by the Consumer Counselor's Office carry equal weight and are in the formal record the Commission considers before making its decision. After completing their analysis, the OUCC's attorneys and expert witnesses file testimony and exhibits. The OUCC, or Consumer Counselor's Office, conducts its review on behalf of all residential, commercial, and industrial ratepayers. If additional parties have intervened in the case, then any testimony they file is due the same day as the OUCC's testimony. A utility has the burden of proof on its rate request, and for that reason, the utility can file rebuttal testimony a few weeks after the Consumer Counselor's Office and any interveners weigh in. As I mentioned earlier, a rate case is very similar to a civil court case. One major difference, though, is that in a utility rate case, each party's direct testimony is filed in writing weeks before the hearing. That's standard practice in Public Utility Commission cases throughout the U.S. because of the complexities of the issues. The practical purpose of an evidentiary hearing is to allow the utility's attorneys to cross-examine the OUCC's technical witnesses and let OUCC attorneys cross-examine utility witnesses. When additional parties intervene, they also take part in asking and answering questions, and the IURC's commissioners and case's administrative law judge can also ask questions of the formal witnesses. Depending on the case's scope, the hearing may finish in one day or may take several days to complete. After the hearing, the utility, OUCC, and interveners will spend the next few weeks making their final arguments in writing. It is standard practice for parties to file proposed orders using the exact language they would like to see the Commission approve. They can also file legal briefs supporting their final arguments. A settlement agreement is possible in any legal proceeding and can happen at any point in the case. Utility rate cases are no exception. When the utility, OUCC, and other parties can negotiate an agreement, they must provide testimony to justify the agreement and show that it is in the public interest. Commissioners may approve, deny, or make changes to any settlement agreement they consider in a final order. After considering all evidence, the IURC makes its decision in a written order. State law requires the order to be issued within 300 days of the case's start most of the time. However, the Commission can extend the deadline by 60 days if it finds cause to do so. Appeals do not happen in most cases, but when they do, they follow the same steps as an appeal from a circuit or superior court. The timeline we've walked through applies to a standard Indiana utility base rate case under typical circumstances. Most other Commission cases follow the same general steps, but with different time frames or no required time limits depending on the type of case. In addition, small utilities can seek rate changes under a procedure that does not include a hearing with attorney questioning, but does include the same standard of review. Thanks for watching, and thanks for taking the time to learn more about the process. For additional information, please visit us online at in.gov/OUCC.